Good evening, everyone. Welcome to Asala's Classroom Talks. Today, it's a privilege and honor for me to introduce to you our guest for tonight, a distinguished jurist of our time, a scholar, a teacher, a mentor, and a global judge. Most welcome, Judge, once again. By way of introduction, Judge, from your days as a young scholar, you know, you're full of curiosity for international law. You rose and became a respected professor, a member of the International Law Commission, and now you are a judge of the International Court of Justice. Was this a journey, one of a coincidence, or a calculated walk?
I'm glad you started with that question. It's a very important question. The answer is, for me, very easy. It was one of coincidence. That doesn't mean that I never thought about it, but I've never planned. I didn't plan every step of the way. My interest in international law began very early. And of course, even at that early stage, I thought it would be very interesting to be a judge on the International Court of Justice. But after that, I just, the central message that I will give you, that I've given to many students, many people, and many young lawyers, is that you have to do what's in front of you and do it well. So I never thought several steps ahead. I always thought, what is in front of me right now? And it didn't matter what that thing was, how big or how small it was. That was what my focus was on, without thinking too far ahead. So it was really coincidence. There was also a lot of luck. So coincidence is one thing, but there was also a lot of luck, because I'm sure you can imagine that the things that I've achieved, other people could have achieved them as well. They just were not in the same position at the time, so they didn't have the chance. But it's not, yes, a lot of luck and a lot of coincidence.
Okay. And Judge, you joined the ICJ, at a time when South Africa
Oops, I've lost you.
in Israel's conduct in the Gaza Strip. I'm just curious to hear from you. How did this sit with you?
Well, I joined the court before. No, sorry. I was elected to the court before the case was instituted and announced. When I first heard about it, I was surprised. But I also understand the rules. The rules are that as a judge, you sit in your personal capacity, and you have to be objective. And the rules allow, in fact, the rules not only allow, they do more than allow a national of a state that's a party to before the court to sit as a judge. Because if, in the event that the state doesn't have a judge, the state is entitled to appoint an ad hoc judge, or at least to nominate an ad hoc judge. Ultimately, the appointment is done by the court. So that I think makes clear that the rules of the system contemplate the possibility of a judge. So for me, it was always, when I heard about the case, I thought, oh, this is very interesting. But there's nothing special about it. There have been many cases involving the United States in which there was an American judge. There's been cases involving France in which there's always been a French judge. There's been cases involving Germany in which there was a German judge. There's been cases involving, you name it. If you think about any of the state in the P5, because there's always until recently, there's always been a P5. There's always been a judge. So there's nothing special about that situation. And the thing, of course, as a lawyer, you have to be honest with yourself, that one, there's going to be a lot of focus. So that focus means that you have to be extra careful not to appear to be biased. So, and it's not that difficult to be. No, it is difficult, but it's not impossible to be objective. We're trained to be objective, and so I think we can be objective.
Okay. And Judge, informed by this South African application, my students have, have made the argument that, the ICJ has jurisdiction over international criminal law. What can you say about this? And what would you say is the difference between the ICJ and the ICC?
Well, yes, the ICJ has jurisdiction over international criminal law, of course. The ICJ's subject matter jurisdiction is broad. It covers any area of international law. The difference, and so that includes international criminal law. There are a number of differences between the ICC and the ICJ. The first difference relates to this question that you asked about the subject matter jurisdiction of the ICJ, and that is that it's basically unlimited, whereas the ICC subject matter is limited to international criminal law, and in particular to the four crimes, to the four crimes under the statute of the International Criminal Court, whereas the ICJ doesn't have a similar kind of limitation. The second big difference between the two institutions is that the International Criminal Court has jurisdiction to try criminal matters, right? So it's when an individual is accused. So it's always the prosecutor against an individual. So the prosecutor against Tladi for having committed, war crimes. The ICJ is, of course, very different because the ICJ has jurisdiction over states, and so the personal jurisdiction is over states. It's always when one state claims that another state has violated international law, and seeking to show the responsibility of that state. So these are the big differences between the International Criminal Court and the International Court of Justice.
Okay. And Judge, we find the ICJ to be a very political court. How do you as judges make your decisions?
I don't know what you mean when you say it's a political court. It's a court of law. It applies law.
Yeah.
It of course is true that many of the issues before it are political in nature, but that doesn't change the fact that it's a court that applies law. I know that in Kenya it's not very popular after the case between Kenya and Somalia, but it's absolutely a court that applies law. I think the question that you ask, the process for how the court applies or the court reaches its decision is a very interesting one, and I can take you through the process. Maybe that'll be very interesting for you to hear. And of course, this process that I'm going to describe now it's a general process. There may be differences and nuances here and there, so I'm just describing the basic process that a case goes through. So the first stage, of course, once there's an application, and again, I'm talking about a contentious case. The first stage, of course, is an application. And then after the application, the applicant will file a memorial, and then the respondent state, more often than not, will object to jurisdiction, in which case the case stops, and when the case stops, then the court will basically have the first phase, so the jurisdictional phase, in which it will determine whether or not it has jurisdiction. This is essentially a mini case, if you like, right? So the jurisdictional phase of the case is a mini case. So here again, there'd be pleadings of the parties, written pleadings in which the applicant would make the case that the court has jurisdiction, and the respondent would make the case that the court does not have jurisdiction. And so this is exchanged at the end of the written pleadings. Then we have the oral hearings, and here the states will then come before the court and make their arguments. And this is the part that's all very public. After the oral hearings, this is when things are now out of the public eye, and this is when the work begins, if you like, for the court. I mean, in reality, the work is before that, because you have to read through all the pleadings. But the decision-making process really begins after the oral hearings. the first thing that happens is the court will have what it calls an Article 1 deliberation, sorry, an Article 3 deliberation. And an Article 3 deliberation is basically an opportunity for the court to sit around the table. I mean, the judges, when I say the court, I mean the judges to sit around the table and to identify what the issues are that they need to decide on. So what are the issues that have come up that need to be decided upon? So that's the first phase, the first step after the hearings. The second step is then every judge will go away, and then the judges will write what is called a judge's note. And that judge's note is basically each judge basically saying, if I were the sole judge in this case, how would I decide the case? Right. So it's if you like, what you think, how each judge thinks the court should decide the case. So there's 15 of us, so there will be 15 notes, and these 15 notes are then circulated. And after that, we have something called an Article 5 deliberation. And in an Article 5 deliberation, we basically deliberate the case. So we give our viewpoints, and those viewpoints could be based on the notes, but you might also have changed your mind because you've read somebody else's notes and that other person might have convinced you. So it's basically an opportunity to say, having read all the notes, here is my position. And then we have a debate. And on the basis of this Article 5 deliberation, the president will then identify where the majority lies. And so you'll say, right, on this particular issue, the majority is here. On this particular issue, the majority is here, et cetera, et cetera, et cetera. And then the court will appoint a drafting committee, which is basically more often than not, it's 2 judges plus the president who will then go off and draft the judgment, or the draft judgment. And it's always 2 judges from the majority. And also the president will also have to be in the majority. If the president is not in the majority, then somebody else will preside over the drafting committee for the purposes of that particular case. So they do the first draft, and this first draft is circulated. And then there are written comments. And then the drafting committee will go back and see if they can incorporate the written comments, if they can make modifications. And then they circulate another draft. And this first draft is called the first reading draft. And then the court will then meet as a collective to go through the judgment paragraph by paragraph. And this can take a couple of days. And then on the basis of the discussions that we've had, the drafting committee will go back again, make more modifications. And then we come back for a second reading and then the vote. And that's basically then the end of the process. So at the end of the second reading, then if you've seen a judgment of the ICJ, you'll see that there's reasoning of the court. And then after the reasoning, there will be there will then be what they call the dispositive, which is basically the answer of the court. So the decision of the court. And after second reading, we then vote on the dispositive to say, yes, we agree, no, we don't agree, and so on. So that's basically the process. If the case goes on to the merits, exactly the same process is followed. So you'll have the written pleadings, you'll have the oral hearings, you'll have Article 3 deliberation, you'll have an Article 5 deliberation, you'll have a first reading and second reading and vote and so on. That's the basic process for decision making. Now, the reason I actually went into that detail describing that was to show, normally when we think about ICJ processes, we often think about the hearings because the hearings are nice and there are people standing, but there's a lot more that goes into that. If you think the climate change case, for example, the climate change advisory opinion, for example, the amount of reading, the sheer amount, the volume of the written pleadings, I suspect exceeded easily 20,000, 30,000 pages. And that's just one case. And of course, we deal with a couple of cases at a time. So it's, so you mentioned at the beginning that I look more tired than in the past. That's the reason.
Thank you very much, Judge, for helping us to understand, where you come from and the context within which you work. Now let's move to another session where we now want to look into aspects of mentorship. Yeah, just to help our young listeners who are law students and young lawyers to understand how they can also undertake their journey in the pursuit for an international career. First and foremost, let's begin by looking at foundational pathways. Judge, what academic and professional foundations best prepare a young lawyer for a career in international law?
Yeah. Well, obviously, the first one is, I mean, the most basic one is you have to have a law degree. I know and this might seem like it's obvious, but I've had many people come to me without a law degree saying, I want to start and do international law. So you have to have a law degree, number one. The second thing, and this goes back to the message that I shared with you at the beginning about doing what's in front of you and doing it well. It it can't hurt you. It helps you to do well in your law degree. And I'm not just talking about doing well in international law, to do well in all your subjects. Because in international law and in reality, most law is very competitive. And so when you are early in your career, you always need something that distinguishes you from your peers, right? So if you're applying for a master's degree, for example, and you're in your LLB, and there's limited spaces for the master's degree, what are they going to look at? Because you've got nothing else to show, they're going to look at your grades, right? So it's important that you do your grades well. It's also important, I think, to be involved in things. I mean, academics is great. It helps you. It's the most important thing if you want a career in international law. But you also have to do other things. Try to be involved as much as you can. Try to help as much as you can. Be involved in projects. Be involved in moot court. My career, by the way, in international law started because of moot court competitions. I got bitten by the international law bug doing the All Africa Moot Court competition. And then from there, I did the JESIB Moot Court competition. And then I knew that this is what I want, that international is what I wanted to do. But so while the moot court competitions first helped me realize what I wanted to do, they also helped me because, again, if you think about trying to distinguish yourself, when you have on your CV and you apply for things, and you have on your CV, one, you did well in school, two, you did the moot courts, and you did well in the moot courts. Again, that distinguishes you. So at every level, do what's in front of you, and you do it well, and it makes you an attractive candidate for that next level. That level, right? So yeah, and I think in my days, I think you could get by with doing an LLB and doing it well and doing many things. Things changed after that. An LLB almost became like, because most people have LLBs, and then that creates pressure for you to have an LLM. And I think these days, at the bare minimum, you have to have an LLM, and even that's often not enough. I think, especially for international law, I don't want to say it's a requirement, but it's more and more people are doing PhDs, which means that they're distinguishing themselves, assuming they do it well, of course. And so that's something that you have to think about. These are the basic things that I think you need. So do well academically in your undergraduate, in your master's. If you do a PhD, do that. And then be involved. If you can write, I know it's very difficult to write when you are young, but if you can write, if you can already now start working on articles and writing articles, all of that stuff is stuff that helps you to distinguish yourself from your peers and make you attractive when you're applying for things. Yeah.
Mm-hmm. Okay, thank you very much, Judge. Allow me to just remind our audience tonight, if you have any question, kindly just type it in the comment section, or you can also just let us know where you are, which institution you're coming from, so that we can appreciate each and every one of us. So let us now move to the second part of this session. And I would like, Judge, to hear from you on matters concerning specialization versus breadth. Yeah. would you advise aspiring international lawyers to specialize very early in a specific field, such that someone is pursuing human rights from undergraduate to master's, international trade law or environmental law, or to maintain a broad competence before narrowing their focus later?
Yeah, look, I think we're all different and different people do different things. My own preference, but this is really my preference. I'll give you examples of people who I know who did it exactly the opposite way. But my own preference is to start broadly. I think in fact, to this day, I don't think I've ever specialized. I know I've gone through phases in my life when I focused on different areas of international law, but I've always seen myself as a public international lawyer, and I've always been interested in the subject, at that very abstract level. That's not to say in moments in history I haven't focused on different areas. So I did my PhD, for example, on sustainable development. So for those years in which I was doing my PhD, I focused a lot on on environmental law, economic law, but I still did those things or focused on those things from the perspective of the basic and the general principles of public international law. There was a time in my life, and I think this is how you and I met, Evelyn, when my focus shifted a little bit to international criminal law. And I did a lot of I did a lot of international criminal law, and even that focus on international criminal law, it wasn't pure international criminal law. I'm not interested in in the elements of crime and so on. I was interested in those aspects of international criminal law that related to public international law. So how do we interpret the Rome Statute? What is the relationship between the Rome Statute and custom international law? What role does the Security Council play in all of this mixture? Questions of sovereignty and so on and so on. So I did international criminal law, but it was always from a focus of public international law. And even in those years when I moved around in international criminal law circles, I didn't see myself as an international criminal lawyer. I've never seen myself as an international criminal. So I've always liked the idea of a broad overview of things. And then I went and I started working a lot on the law of the sea. And then I worked on the prohibition of the use of force. But I've never ever lost that interest in, right? And so whenever I was looking at something, a specific area, I always knew that it fits into a bigger thing, and I was more interested in the bigger thing. I know people, my own mentor. I think so Franz Fuyun, you know Franz Fuyun well. I think he was your supervisor, no? Was he your supervisor? Well, anyway, I don't remember. But,
no.
Yeah, but he was a human rights lawyer first, and he moved from human rights, and then he sort of broadened the scope to international human rights law, and I guess now he does a little bit of international law as well. But we all do it differently. But I think the bottom line is you have to make your choice, and you have to stick with it. There's no right way and there's no wrong way. My own preference is always broad. And the reason I like broad is it's so easy for you to, for me right now, I don't think I know much about investment law. I don't have expertise in investment law. But there was a time I was asked to be part of a legal team on an investment arbitration. And I was able to join using my skills from public international law and to apply those. So I think there's always value for me. There's always value in broadening your scope, and then you can always, if you want to, you can always narrow. And the beauty about coming from a broad background is that when you're tired of that area that you're focused on, you can always come back and you can always find something else, right? You can always do this, which is pretty much what I did.
Okay, thank you. Thank you very much, Judge. I know you've already mentioned the fact that quite a number of people are now increasingly doing PhDs, and master's programs. But sometimes, Judge, you realize that when you pursue a PhD, you cannot be compared with your colleagues or your contemporaries who and get into the practical aspects earlier enough. And so isn't there a position where we can balance between, academic achievements and the experience in litigation, diplomacy, or public service? Or, how would you compare these two in terms of pursuing an international career?
Well, again, I can only talk about me and my experience. I never had to choose. So I did I finished, in fact, even before I finished my LLB, I started teaching, which I think is is part of the career path. I started teaching, and when I was doing my PhD, I worked for the Foreign Service. So I was engaged in the practice of international law. I was doing. I don't think one has to choose. I think you can do. I think you can do. You can do. Especially when you're thinking about it from the perspective of a PhD. You don't have to do a PhD. If you do a PhD, you don't have to do it full time. Number one, and two, the thing about a PhD is that even if you do it full time, you're able to do other things. When I was doing my PhD, I wrote so much. I think I published a lot when I was doing my PhD. I had a student who was doing something on deep seabed mining, and I connected him a lot with people in the practice at the International Seabed Authority, and he did a lot of projects in that area. So there's always space, and there's always a possibility, and there's always chances. And I think it's just a question of taking opportunities where they come. PhDs don't prevent you from doing other things. In fact, PhDs open up the possibility of you also engaging in practical things. There are many people who come to argue before the International Court of Justice that are part of bigger teams, of course, but that are in the process of pursuing their PhDs. And that's there are other people who are arguing before the International Court of Justice because they did their PhDs with professors who appear before the International Court of Justice, and so they get exposure, and so it opens up possibilities.
Yeah, okay. Thanks a lot, Judge. Now, let's get more realistic, Judge. What are the realistic chances of entry into the legal work for lawyers from developing countries, especially taking into account that some of these people do not have immediate access to international institutions?
Yeah, that's true. There's no hiding from that. That if you're talking about international practice, particularly practice in the sense of appearing before international courts, there is a mafia out there, and that mafia strictly controls it, and they make sure, or they work very hard to make sure that other people aren't able to join in. Some people have been able to break through. Your national, for example, Phoebe Okoa is somebody who has been able to break through. I think her first case was Gambia versus Myanmar, which is a big case, and no, in fact, her first case was Somalia, Kenya. That was her first case, and with advisory opinions, we've seen more and more people also getting involved. But I mean, advisory opinions are different because states don't really have at least from my impression, they don't really have a stake in them so much, so that it becomes easy to sort of say, we'll just let a person that we might not. Yeah. So you can see a space opening, but it's very, very hard. In fact, let me stay on this subject first, and then I'll go to other areas. Part of the reality that we have to be honest with ourselves as well, right? We have to be honest with ourselves and say that our governments also, when they have cases, they think about Europeans. And I'm talking about African governments, right?
Yeah.
Even when you have a person from Africa, it's normally I don't want to say a token person, but it's normally one person where, for example, I think the government of Kenya said, look, for our case, we want to have at least one Kenyan. But the team itself is a team that's made up of Europeans, Americans, and so on. So I mean, Europe doesn't have a lot of cases before the ICJ. America,
Mm.
most of the cases, the biggest clients of the ICJ are, Africans and Latin America. So it's weird that the lawyers are. In fact, I wrote an article in the University of Connecticut, no, sorry, the University of California, Irvine Journal of International Law, something like that, on equality and representation in international law, looking at the ICJ and the ILC. And one of the things that I looked at was who's representing states, and it's just staggering who's representing states. So yes, that's just simply because there's a mafia, and it's very hard to break. It's very hard to break into that mafia. It's hard for most people to break into that mafia. And what that mafia does is it controls the system by saying, we will put in our people. So, if I'm part of the mafia, and Evelyn, you are my student, then at some point I will bring you in, and then you acquire a name, and then when I'm about to leave, you're now my representative. That's how it works. Unfortunately, people are aware of it, and hopefully, because people are aware of it, there's a possibility for change and shift, but it's going to be hard. And I think a lot of the answer and responsibility lies at the hands and the feet of African governments and Latin American governments for continuing to appoint lawyers from Europe who are not. Okay, I shouldn't say that. Let me stop there. And then, as far as other things are concerned, like employment at the ICJ is also a possibility, but it's also hard because there's language issues. The working languages of the courts, English and French, and if you have to be proficient in one and at least have a decent basis of the other one to be able to gain employment at the registry and those kind of things. And so there are all kinds of things that sort of block pathways, but but people are trying to break those ceilings. People are
Yeah.
really trying to break those ceilings.
Okay. Thank you, Judge, for being very honest with us. It's important, yeah, so that we don't have unrealistic expectations, even as we soldier on in our search for international careers. You mentioned about English and French in the ICJ, and I have seen quite a number of young lawyers and young professionals really trying to pursue multilinguals. Yeah, so you find someone taking up French, someone studying Spanish, Portuguese. What are the chances that really, when you take up these languages as your second option, yeah, and even if you enhance your cross-cultural experiences, does this really open up more opportunities for you in the international space?
Yeah, I mean, if you think so, again, I'll talk about the ICJ. If you So one of the positions for young people at the ICJ, which is very popular, is the associate legal officer, which is basically a clerk, the law clerk for the judges. And there, the requirement is, as I described it to you, you must be proficient in one language and have a decent ability in another one. For that, you put in your CV that, and then you get called for an interview. In the interview, if you are English speaking, your interview will be in English, and you will be asked to answer one question in French. And you also have a written exam. There'll be if you're English speaking, you answer the exam in English, and there'll be one question that you have to answer in French. So in that sense, yes, even if you learn, I mean, if you've been learning French for 2 years, 3 years, whatever, you should be able to be okay. In fact, even less, you should be able. I mean, obviously, it depends on how intense you've been learning it. You should be fine with the language. But yeah, it's useful to. I myself am not a big fan of the language requirement. I try to oppose it as much as I can because if you take you, for example, and you've got this little bit of French, the reality is that you're never ever going to use it for work. It's enough to get in, but it's not enough to help you work because you can't work with that little bit of French. So I find it to be an artificial requirement, which has the effect of excluding many people, right? So you're excluding much of Asia and you're excluding much of Africa. I mean, you're including all of Anglophone Africa, so much of Southern Africa, much of East Africa, and I think that's a problem. I think that's a big problem, but that's the rule as it is. And I mean, yeah.
Okay. Thanks once more, Judge. Now, Judge, we see that international law is often accused of being more aspirational than enforceable. And, as a young lawyer, we have this idea and we want to maintain it, but again, successfully navigate through the political realities of international justice. What are some of these realities? Would you like us to know? And how would you advise a young lawyer really who knows that, or have this idea that international law is more of aspiration? I don't know. I would like to hear your views on this.
Well, I would disagree with this young lawyer, and I would say the following. Think about the number of times that you have crossed the road without going to the traffic light. So you've jaywalked. Like that's an offense which goes unpunished, and it goes unpunished everywhere, right? And maybe you might say, "Oh, but that's not serious, prof. That's trivial thing." That's okay. Think about the number of murders that go unsolved. There's an offense. That offense, I'm sorry. So there's a prohibition, and that prohibition is breached, and there's no consequence. So there's no enforceability, right? I mean, what's the percentage of murders that are solved in? So in other words, what are the percentages? So what's the percentage of offenses that lead to consequences? So I say this to make the point that I don't judge the a legal system by how much how much it's enforced. And then I could flip the coin, by the way, and say I don't know how much your students or you travel, but if you travel a lot in the air, there's I don't know how many planes, but there's lots and lots and lots of planes in the air at any given time, and they don't crash into each other. Rarely. Let's touch wood, right? Why? Because there's compliance with international law. There are international law rules that govern all of that. Think about if you go with your passport to an immigration person and you give them this little book and they look at the little book and they let you in. Why? That's so we don't think very often. We don't think about the number of times that international law is actually complied with. It's far more often than the instances that it's not complied with. We think about the instances of non-compliance because they are big, but they're very few when you think about, so when you think about the number of times of compliance, the respect for the immunity of a head of state, the respect for immunity of a diplomat, the respect for the territorial waters, the respect for the exclusive economic zone. I can give you many examples. They're not sexy because they don't involve bombs and things like that, but they're still international law. And so what I'm saying to you is if you look at international law, you'll find there's a lot more compliance than not. And if you look at domestic law, you'll find that there's a lot of non-compliance. And so if you're going to question international law, it's so yes, I wouldn't get despondent about international law and its compliance. Again, I don't want to romanticize international law. There's a lot of things wrong with international law. But I don't think compliance is the thing that one should be thinking about all the time. If you want to judge international law, there are other things that you can judge international law about. I judge international law for why international law is so uncaring about poor people. That's something. If you want to criticize international law, you must come to me with that. I think that's something but the compliance thing I find to be blah, tiring.
Okay. Thank you very much, Judge. Now let's talk about the aspect of diversity. Diversity in gender, diversity in regional aspects within international judicial appointments. What advice would you like to give those groups who are underrepresented? And would we fall under those groups that are underrepresented?
Would who?
Do we fall under those groups that are underrepresented?
Who's we? Because there's a lot.
Oh, okay, yeah. By we, I mean, the young lawyers and law students and lawyers from developing countries.
Yeah. I mean, in some bodies, of course, like the International Court of Justice, you've got understandings that there will be 3 African judges, and so in that sense, the chances are there'll always be 3 African judges. I don't know whether or not that's probably not equitable if you look at the world, because if you think about the other region, or the other region which we call WEOG, Western European and Others Group, let me see how many judges they have. So Western European and Others Group, which is small, right? It's made up of 32 states or something like that. So currently they've got the German judge, they've got the American judge, they've got French judge, they've got the New Zealand judge, and normally they would have had the British, but then they lost, right? The British lost their seat in inverted commas to an Indian. So they would normally have 5 judges out of 15. This is a group that's made up of 32. So there's something very wrong with that system, which already shows, lack of representation. So yes, I mean, there's a lot of issues of representation. There's obviously issues of representation of gender. And that's if I go to the International Law Commission, which is another body that I belong to, it's not just representation on the commission, so both in terms of race, in terms of geography, in terms of gender, but also representation as special rapporteurs, which is the institution that drives the work of the ILC. So no, representation is a big issue. That said, it's a big issue and it needs to be addressed. How we address it is, of course, through nomination processes. That said, I think it's also important that we remember that it's not enough just to have 3 Africans on the court, or 4 Africans, or 5 Africans. I would much rather have 2 Africans on the court that are impactful, that know enough international law to be able to engage and to change direction, than to have 5 Africans or 6 Africans that are just going to sit like this and that are not going to be able to convince anyone of anything. And so there's a balance. It's not just about, right? So you need to make sure that the people that we put, that we nominate, are actually going to be able to do the job. And do the job doesn't mean, read a statement, or it means when we do the deliberation and when we do the reading of the judgment, that you're going to be able to participate and convince others. And I think that's just as important as the numbers. So when we look at representation, we shouldn't just look at the numbers. We should also look at, the quality. And I think that's really important. And that applies across. So whether you're talking about race, region, gender, and so on, it cuts across. We need good quality.
Okay. Thank you very much, Judge. Let's also talk about the issue that has become very rampant and very common in Kenya. I'm sure it is common in other African countries as well. Most parents and most young people want to pursue, or their children to pursue, careers at the international level. And we have this common occurrence where young students prefer going to foreign universities, especially Western universities, with the hope that they can get, foreign or international employment, and young people also pursuing foreign curriculums with the hope that it can help them transition to the international career. I don't know, to what extent would you encourage this, or what would be your advice to this dilemma?
Well, I'm one of those. I did my LLM in the United States and I did my PhD in the Netherlands. So
yes, you're a victim.
I don't know about being a victim. I guess I'm a beneficiary as well. Look, it's important to trust our own institutions. But it's also important that those institutions are resourced, sufficiently resourced, and I mean both in terms of capital, finance, and also in terms of the personnel, to be able to help them to be competitive. There is, and I'll tell you this for free, uh, um, I don't think much of my LLM from the United States, and I didn't even when I went. I knew that it was, to go to the United States. Master's programs in South Africa. I can only speak about South Africa, but master's programs in South Africa at my old university, at the University of Pretoria, are of a very high quality. But there's also the symbolism, right? So the symbolism of a master's program abroad is probably what drives many people. If you can say, in fact, you know what the funny thing is? I know many people who have PhDs from, say, from South Africa or from some other African country or even from Asia, wherever, but they also have an LLM from Harvard. But they would write their name and then write LLM Harvard, and they wouldn't even write the PhD. I've seen that.
Yeah.
And I find it incredible that the selling power of a master's degree, which is not even a master's degree, because I mean the point I was making earlier about master's, my own master's degree, is that a master's degree from the United States is not really a master's degree. It's a collection of their JD program, of their JD courses, which is basically their LLB courses, and you put them up, and then you put them together into a number of credits, and then you've got a master's degree. But it sells. And remember, what part of what you're trying to do as an individual is you're trying to put yourself in as best a position as possible. And I guess we could all make sacrifices and say none of us are going. We're going to show that our universities. But I think it's important for the universities themselves to be competitive. And maybe part of the thing is, the universities are not competitive because we're being judged on the wrong scales. It's such a complicated matter, Evelyn, because how do we decide which is a good university? Well, we decide if it's a good university depending on, where the professors have published. Where do we decide? No, we want to see if the professors have published at, I don't know, I can't, EGIL or AGIL.
Yeah.
Who are the editors at EGIL and AGIL? The Americans and Europeans. Who are they likely to publish? So it's a complicated thing, and you're right. In an ideal world, our universities would have a free shot and would have a fair shot, not a free shot, but a fair shot at competitiveness, and our students would stay. In fact, it's good to move, but what would be good is if the movement was both ways. Because part of the real value of movement for me is not the education. It's not, the real value of going to a United States or going to China or going to Cambodia or going to wherever is the ability to engage with other people and to be able to converse and communicate about a subject that we all know and that we all hopefully like and care about, but on which we all have very different views. And one way in which we can understand each other is by talking, and cross-fertilization is good. So the best case scenario is if Africans move elsewhere. Not all Africans, some Africans move elsewhere, and people from elsewhere also move to Africa, and then you have this. That's the best case scenario. But it's hard when I was at the University of Pretoria, I tried very hard to attract students from elsewhere into my PhD program. And when I say elsewhere, I mean elsewhere outside of South Africa. So on the continent, outside of the continent, I suspect I have more students from Kenya who have graduated with PhDs than I have from South Africa. I think that's probably correct. That's probably correct. Yeah.
Okay. Thank you very much. Now let's engage on the ethical questions. What would you say are the personal values, professional habits, and commitments that distinguish individuals who have excelled and have become credible in international legal practice?
I don't know. I never think about such things. I can just tell you about me. What has helped me excel is I have enjoyed what I have done. I have done it full force. I never think about things like, oh, the 7 habits of a successful. I see these books and I think it's just, I find them all too theoretical. And maybe there's something to them. I don't know. I don't want to discourage anybody who has these books that tell you about habits, and I think you just have to work hard. That's that was my driving force, and I was able to work hard because I enjoyed what I was doing. I enjoyed international law, and I was able to work hard. Yeah, I mean, if you talk about success, that's it. There are of course other things that are important. It's important to care about others. But if you're, yeah. I'm sorry, I don't have a more intellectually stimulating answer because
No, it's fine.
I never quite understood those things.
Okay. And now let's, finish with a question on academia, because, this is our space, most of us. And I know, Judge, you have published 100 plus publications, yeah, which is intimidating, yeah, to some of us, but we hope one day we will walk in your footsteps. But nonetheless, do you think, when we focus on publications as academics, we leave anything behind, or, does it give us a chance to benefit in international spaces?
Evelyn, things are changing. I can tell you things are changing. It's not like in the past. Well, I mean, it still is like in the past, but things are changing. So I don't know if it will be like this in the future. I see people writing things now very quickly, blog posts, and I see that, and I think part of it is a recognition that this old thing of articles where you write something and it takes 3 years for it to be published, and by the time it's published, it's like, okay, this used to be news 3 years ago. So I think things are changing, and I think things are going to change rapidly. So I don't know if in the future the things that have made us successful are going to be the things that new academics are going to, I don't know if it's going to be all that fashionable to say I have 160 publications. I don't know. I think with publications you do leave things behind. I mean, it's good to have research work that you've really poured your heart into, and that you thought about over a long period of time. It's good. I think it leaves things behind. And there are, I can tell you, to this day, there are times when I get stuck on something in a thought, and I go and I open something that I've written many years ago, and it opens up things. So that's one. The second thing that I want to tell you is, you contextualize your question by referring to leaving things behind. I've always believed that the things that we leave behind that are the most important are people. And obviously at some point it gets a lot, because there's only so much that you can do. But I used to tell some of my students, them, I will know that I'm a success if I walk into a room and people look at me and they don't know who I am, and then somebody says, oh, that's so and so's professor. Because that would mean that so and so, the person who you were a professor to, has made it so big that you are actually referred to in the context of that person, right? So if they say, oh, that was Evelyn's mentor, it means that that Evelyn has really made it in life, so much so that people might not know who you are, but they will be impressed when they find out that you are actually the person who, who mentored Evelyn. That's the kind of thing that for me is really important. And I've always told my students that. And that's why, I mean, I don't do it so much anymore because I just simply can't. But I used to, I mean, how you and I met, you were never my student. If my memory serves me correctly, you just said, well, you'd like to be mentored by me, or and I have lots of people, so like the people on the continent, and people from Asia who have just written to me and said, would like to work with you. And I said, okay, let's see what we can do. Obviously, again, at some point it becomes a lot, but I'm very happy. Those are the things that I'm really proud of, and those are if you ask me, what do I leave behind? If I were to finish my career tomorrow, those are the things that I leave behind. I love it when I'm in my office and I look at the books that have been published, of my students, my former students. That gives me great pride. It makes me feel like I've accomplished. That means more to me than my own books that I've published. So yeah, that's what I
Okay.
leave behind, I hope.
Thank you very much, Judge. Now, of course, I would like to hear how you feel to be the judge of the ICJ today. I can't wait to hear from you. What's the feeling like? And of course, we are all proud of you. But then, Judge, what do you plan to be your legacy at the ICJ?
So right now, what I feel like I am very tired. That's the thing I feel like most. But
Yeah.
no, but I'm loving it. I mean, it's
Mhm.
it's a tire. It's been a tiring year and a quarter, whatever it is. But it's been very enjoyable because the cases that we've dealt with, have been very significant, have been very consequential, and they've involved very interesting legal questions. So very interesting and also very consequential. And I think these are
Mhm.
two very important things. Um, in terms of what I leave behind, what I hope to leave behind, because obviously I think I've only
Mm.
been on the court for a year and a half, or just over a year and a half. I probably don't have that much to leave behind now. But what I hope to leave behind at the end of my 9 years is I hope I would have pushed the court, towards a jurisprudence that's more caring, that's more based on solidarity. I've often spoke about that in my academic years, and already at the court, that's what I try to do. I'm not always successful, but it is what I try to do. And so I just, yeah,
Mhm.
I hope that's the legacy that I leave. And I also hope to leave a legacy
Mhm.
of recalling that,
Okay.
law can't solve everything.
Okay. Excellent. So thank you very much. We have enjoyed that session, Judge, with you.
Thank you very
Now
much.
let's turn to the question in the comment section. And our first question comes from Shayla Bahati. I think this one you've dealt with. Shayla is asking, how can one best prepare to position themselves for a career in international law in terms of ethics? I think you've dealt with this, Judge, so we don't have to delve in it. The second question is from Patience Kadambi. Your Excellency, would you kindly share what qualifications or attributes the ICJ looks for in applications seeking to secure fellowship positions?
Okay. So I suppose by fellowship positions, you're looking at judicial fellowship. Um,
Mhm.
it's hard for the judicial fellowship because the basic requirement is that you must be, you must have a law degree. I mean, that's the requirement. But that's the basic requirement. But as I said to you, because there's so many applicants, it's not enough to have
Mhm.
just to meet the basic requirement. It's not enough. You also have to distinguish yourself. And how do you distinguish yourself? By all of those things that I said. Make sure that your grades are really high. Make sure that your grades, in particular in international law, are really high. If you have an
Mhm.
opportunity to write something, write something. If you have an opportunity to be involved in some international law project, be involved. If you have an opportunity to learn a language, extra language, learn an extra language. So it's all of these
Mhm.
things that you can do that make you a much more attractive candidate. If you have an
Mhm.
opportunity to do the moot court, do the moot court. So all of these things,
Mhm.
just try to distinguish yourself, as much as you can.
Thank you very much for that clarification. Another question from Wendy. Your Excellency, does the ICJ have any structured pathways that enable students from the university, like myself, to apply for an internship?
Well, no, it's not an internship. As I said, it's a judicial fellowship, which is the one that I've just spoken to about now. So that's the main things, the main opportunities for young people. It's a judicial fellowship program, and it's for the judicial fellowship program. It's not the student that applies. It's not the young person that applies. It's a university would apply on your behalf. So recently we had a judicial fellow from Kenya, actually, from Strathmore University. Not in the year that, so the judicial fellowship runs from September until July. So until this past July. Yes, so that's the one possibility, which is what I've spoken to you about. It's the requirements are not strenuous, but as I say, because it's competitive, you have to find ways to distinguish yourself, and that's and then the other one I've also spoken about this earlier on is the associate legal officer, or the P2, or the law clerk. That one is much more of a job application, so it's not done by the university, it's done by you yourself, applying directly to the court. And that's so the judicial fellowship program is a 1-year program. The associate legal officer is a 2-year program, which is renewable once, so it effectively becomes a 4-year program. It's a lot more of a senior position. I mean, a lot of judges rely on their P2s for a lot of their thinking and their work. So for that one, you have to be quite senior. I mean, there are people who have been senior lawyers at international law firms where they have been practicing international law and have left those jobs to go and be associate officers. And I think that gives you a sense of how senior you have to be for that position. There are also internships at the court, but not with the judges, at the registry. And I don't know that much about them. And I think there may be about 3 or 4 internships. I think you just write to the registry and you say, you'd like to be an intern, and then they'll see if there's a place or something like that.
Okay. Next is a question from Elvis Mogesa. Hi, Judge Clady. Great to see you again. My question would be,
but Elvis shouldn't ask me a question. He just saw me 2 weeks ago, and he sent me an email last week.
He should have asked the question, but it's fine. It's coming up in this discussion. So my question would be, how important is it for an African international lawyer to be deliberately keen in ensuring internal law works for the subaltern?
I don't understand the question, Elvis.
Okay. So Elvis, your question is not understood. I don't want to interpret it my own way. So let's move to Jafet Alande. What's your take on international bar exams like the UK ones in giving one a leverage in international law practice?
Yeah, I mean, it's useful, I guess. It's the same question you asked me earlier about. Well, it's the answer is the same one you asked me earlier about. About going to universities, abroad. Here, the difference is, though, that if you look at the people who practice before the International Court of Justice, a lot of them are in bar councils in the so in the United Kingdom, whether it's Essex Chambers, Essex Chambers, Downing, Doughty, whatever the case may be. So it helps, but in many ways it's also counterproductive. I mean, no, it helps. It helps you as an individual, but in the greater scheme of things, it perpetuates this narrative that to practice in international law, you have to be in the United Kingdom. So it's kind of difficult. It's, I wouldn't tell you not to do it. And maybe that's the solution. The solution is just the other thing, of course, is, even if you're able to be admitted in the UK as a barrister and you're able to join one of those chambers, to be able because international law work is much sought after. That's what everybody wants to do.
Mm-hmm.
So to be able to do that, you'll have to attach yourself to a senior counsel, or as they call them, their King's Counsel, um, that has international law connections. So again, it's that what did I call it? The mafia. Right? So you have to break into the mafia. So yes, if you can do it, do it. It'll help you. It can't hurt you. Just be aware that of yeah.
Mm-hmm.
I mean, if you can do it, do it. I mean, I would do it. I'm
Okay.
not gonna sit here and say that I wouldn't do it if I was trying to break
Mm-hmm.
into international law and I was struggling and there was an opportunity, I would probably do it. But there is this bigger thing, and
Mm-hmm.
this bigger thing is are we perpetuating the narrative?
Okay. Okay, the next question is from Ayaga Max. Great contextualization, Judge, Prof, and very relatable. On writing articles, it's a bit difficult to get our papers published in top journals. What would be your perspective on this? Ayaga Max, UN.
That's just true. That's
Yeah.
very true. A lot of it is
Mm,
so. A lot of it is gatekeeping. Um,
yeah.
but there's also some of it that I don't know if we don't naturally know how to write, right?
Mm,
Writing is a skill that you develop, and so my advice to you is just continue writing. Continue writing and continue reading. Make sure that you improve your writing. Submit your papers. When you get comments, even if they don't publish them, if they tell you why they didn't publish them, see if you can improve the article. And yes,
yeah.
and fortunately, by the way, so as I said to Evelyn earlier, um, the international law environment is changing. And I think people are now interested in shorter pieces, blogs, and so on. So write those as well. I mean, write those as well. Obviously, if you want a job in academia, you have to be, you still have to publish in mainstream journals, but
Mm,
get your name out there, and writing short blogs while you're writing your articles, or you're trying to have your articles published, also helps because it gets your name out there, and having your
mm,
name out there is just as important. Look, now I know Elvis.
mhm. Thank you. Thank you for that, Prof. Another question from Nelson Anei, UN Parklands. What ethical dilemmas are most common for judges and lawyers in international law, and how do you navigate?
I guess the biggest one is when you're looking at a case, and even before you've heard evidence, you have an idea of where you want, or
Mm,
you have a um me personally, I don't think there's anything wrong with it. I think the important thing is that you have an open mind. Even if you have a point of departure, you think this case, my general sense, my feeling is it ought to go this way. What's important for a lawyer, for me, is that when you start reading the material, you have an open mind to be able to say, this is the way I thought I was going to go, but now having read the material, this is where I think I'm going to go. When you start listening to counsel argue, you can say, after reading the material, I thought this is where I was going to go, but now based on these arguments. So that's the ethical dilemma. The ethical dilemma is we all have point of departure. We all have policy preferences, and anybody that tells you they don't have a policy preference is lying to you. But
mhm.
the key thing for a judge is to be able to have an open mind.
Okay. Thank you very much
I hope we don't have too many
for
more
that
questions.
clarification.
Uh, I hope we don't have too many more questions. I had a long day. How many more do we?
Okay. Another one from Patience Kadambi.
Uh-huh.
Your Excellency, could you kindly share what qualifications or attributes the ICJ looks for? Oh, no, no. I think this one
We've
is a
done that
repeat.
one.
No, 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 no. I think we are finishing. Uh, Another one asked Peter Kamodo would like to know whether there are job opportunities for young professionals. So that's related to the job.
Where at the
How,
ICJ?
yes, I think it's the ICJ, though
Yeah.
it does not state.
Yeah, the ICJ there are. In fact, there's a call now out for applications. If you go on the ICJ, I think it's on the ICJ website. There's a call for applications for the P2s, the position I was telling you about. But as I said, they have those requirements. You'll see those requirements. But there are also other opportunities. I mean, it's not just the ICJ. Just because I come from the ICJ, I shouldn't just speak about the ICJ. There are other international organizations, but they're also just as difficult to get in. There are also, NGOs that work on international law, and I think Evelyn will be able to tell you about some of those in the international criminal law space. But there's also NGOs in environmental law space. There's nationally based NGOs that work on international issues, and those are also a great way to get into the space because those NGOs engage with their partners elsewhere. Through that, you get known, and being known is one of the critical things. It's one of the critical things in this line of work.
Okay. And there's an interesting question from Michelle. Hello, Madam Evelyn and Honorable Judge. Based on the current situation in Tanzania, when voices are silenced and freedom decay, how can an advocate of global rights pave the way and come to our rescue?
So Michelle, what happens now if I answer this question and then somebody takes Tanzania to the ICJ? Now I have to recuse myself because I answered your question. Huh?
Yeah, okay. So let's move on. I want to build a career in INGO, yet with reduced donor funding, opportunities are shrinking. How can one stay effective and build a meaningful international career in this changing landscape?
Yeah, I think I'll tell you, I had a meeting today. I've just been given extra responsibilities as the head of the African Foundation of International Law. And I was saying, well, so I had a meeting with the people who've been involved and asking them, how do we get things going? What do we so what are the options? And one of the issues, of course, is money. It's finances. By the way, the foundation seeks to answer a lot of the questions that you've been posing about careers for young African international lawyers, and opening up pathways. But unfortunately, there's scarce resources, and part of the problem, I think, there's scarce resources, and there's many entities that are asking for money, for funds, but they're asking from the very same people. So there's obviously also fatigue from the donors that's saying, oh, somebody else coming to us. So yeah, it's tough. I'm afraid I don't really have an answer for that except to say that it's difficult. But yeah. So I will say one of the things that we thought about today is we thought about doing things that don't cost money. They don't have to cost money. We thought about having things like a PhD program, for example. A PhD workshop, for example, for African students. That doesn't have to cost money if you have it online or something like that. But yeah, it requires organization and so on. But we can just use Evelyn's Zoom account because I don't have a Zoom account.
Okay, Judge. I think we have two more and we are done. Glory Gidenji, what other career paths are there in international law other than being a judge or working with the ICJ?
Lots. So as I said, there's all of these international organizations and all of them, whether it's the UN, whether it's WIPO, there's so many. And of course, don't forget the one that starts it all for most people, being an academic. That's also, that's what started it for me. But there's also working for your own governments, and not just working for the foreign ministry is obviously the best place, but in other government departments as well, there are units. In other government ministries, there are units that work on international law. So there's many places, and my talk today has been limited by the fact of my own background, and so the questions have concerned my background. But the reality is that there's so many different places, international organizations, NGOs, universities, think tanks, you name it. There's a wide spectrum.
Okay, and another one from Elvis. What are your thoughts on pedagogy? of international law in African universities. I
Yeah.
would argue that a large majority of our lecturers still center on doctrinal and mainstream ideas compared to critical.
Yeah. So, by the way, so before I answer this question from Elvis, let me also give a shout out to him. Somebody asked me a question earlier about publications and doorkeeping. There are other journals in which you can start off with. There's, my own university, my former university, the University of Pretoria has one. I think it's called the African Journal on Human Rights or something like that. I can't remember the name. But Elvis is also an editor of a journal. I have a copy of it there, which is very interesting, and it looks very professionally done. So all of these things are also a way to sort of get your name out there. To answer your question, I think the assumption of your question is that so critical teaching is the best approach, and that may well be so. But you still need the basics. I've come across international lawyers who sort of teach, who are crits and who teach so critical approaches without basics of international law, and it's very unhelpful. I find it's very unhelpful. Those people are not, so those students are not going to be able to make an impact in international law. I've seen it, unfortunately. I think it's you can't be critical of a subject that you don't understand. I mean, you have to at least understand the subject, and once you've understood the subject, I think then the next question is, right, now I understand this. There's something wrong here. You can't just start, there's something wrong here, when you know absolutely nothing. Right? And that's the sense that I get from a lot of crits, is they're very eager. Remember, when you teach, if I am teaching a class, my function is not to make you me. If I'm a critical scholar, my function should not be to try to turn you into a critical scholar. I need to know what my audience is, right? So if I'm teaching a class for the first time in public international law, if I'm teaching a class of first-time international law students, so these students haven't done international law, it makes very little sense for me to start being, saying, TWAIL and CLS and those things for me are for people who, so if I'm, with a group that has done several years of international, and they understand the subject, and they themselves will be able to understand the flaws and the weaknesses and the problems. In fact, I'm one who, I'm not a big fan of theoretical critiquing. I think you can critique without theory. Right? You look at something and you say, this is wrong. I know it's wrong. I don't need a theory to explain why it's wrong. I know it's wrong. Right? And then you can explain that. That's my, and part of the problem, so if you ask me, the basic question, what's wrong with our education system for international law? It's that we don't do enough of it in undergraduate. And because we don't do enough of it in undergraduate, there's no space for critical thinking about international law. Because all that you can do if you have a semester, I don't know, so what the situation is in Kenya, but at the University of Pretoria, international law is done at undergraduate level, is done for one semester in your third year, and that's it. When I have master's students, where maybe you could be doing critical thinking, you can't do that, because how are you going to teach? How are you going to teach critical thinking to somebody who's just done a semester of international law?
Yeah.
So that's my view based on many years of teaching. I've been teaching since the late 1990s, and that's my view. Maybe I'm old-fashioned, I'm conservative, and I wouldn't make it in the new world, but that's my view, Elvis.
Okay, Judge, I don't know if you want to answer this one from Michelle again, Honorable Judge.
This is my last one, because I really have to,
Yes, this is your last one. With mass displacement surging and accusations of war crimes mounting, how can the ICJ ensure that the war-torn people of Sudan don't become forgotten victims of geopolitics and impunity?
I have there was a thing that was sent to me last week. I'm gonna find it and read it to you. Because I think your question is just give me a second. Who was sent to me? I must go to my group. What's the group team? To my team group. And so it reads, it's a social media post by somebody called Julia Mtseva. And she's saying, I'm going through separate opinions and declarations of the UNRWA advisory opinion. And I think at this stage, we can establish with full confidence only one thing. Judge Tladi became our official representative of, quote, law won't save us, unquote, movement. So I don't think that the International Court of Justice can save any situation. And I think it's unrealistic to think that the International Court of Justice is able to save any situation. I think all of these things require, I mean, what the International Court of Justice can do is, if it is seized with the matter, assuming it can be seized with the matter, is it can render a decision. And that decision may or may not be helpful to the situation, but that's all that it can do. But that decision is not going to solve the problem. When Evelyn asked me, what do I want my legacy to be at the court, I talked about solidarity. The other thing I talked about is the idea that law is not enough. I can't remember how I put it when you asked me the question, but that's what I meant. Law can't save you. There's only so much that law can do. The court said it in the climate change advisory opinion that this climate change problem is not going to be resolved because there's an advisory opinion. It doesn't matter how good the advisory opinion is. If there's a court case, relating to Sudan, and the court issues a judgment, it's not going to solve the situation. So if you're looking for the court to solve situations, then you're going to be very disappointed, to Michelle. But also, I'm not going to speak about Sudan because, again, who knows? There's a court case, and then I speak about Sudan, and somebody says, yes, Tladi said this and this and this and this, he has to be recused. I think Michelle is trying to get me recused from court cases because this is the second one about a specific situation that you're asking me. Thank you. You're muted, Evelyn. You're muted.
Sorry for that. My screen just went off.
So okay.
Some of the problems we face, but nonetheless, yeah. So just to say a big thank you, Judge. It's been really a big opportunity for my students to meet with you and just to interact with you. You can see the amount of questions. I've not actually been able to read all of them. So for those left out your questions, please forgive me. We can follow up with these questions. Yeah, and forgive Judge. I know he's very tired. He's had a very long day.
And it hasn't finished. I still have things, they've been coming in. I still have things I have to do.
It's really a huge sacrifice, Judge. Thank you so much. And thank you for our audience. Please feel free to join us whenever we have these kinds of talks, and it's all for your benefit. So God bless you all. Thank you very much.
Thank you very much. Thank you. Bye-bye.
Thank you.